Ross?
Yes, Your Honor.
Yes. Court is calling 2025 CR 004086 off the record for a moment. And Norma, Mr. Hayek is not here. Mac is here. Could you let Mac know which client that is? All right, we're back on the record. Could I have parties announced for the state? Defense?
Anita Perez for the defense.
I'm sorry, what? Okay. All right, and the court is also calling 2025 CR 003533. And you're Mr. Ross? Okay. Counsel, each of the cause numbers, did you receive all discovery and review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Ross, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented in the cause number ending in 33? And are you proceeding on the indictment as presented in the cause number ending in 86? Mr. Ross, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
And cause number 2025 CR 003533, you're charged with assault, family, household, impeding breath or circulation. And in cause number 2025 CR 004086, you're charged with violation of bond or protective order 2 times or more within 12 months as a 3rd-degree felony. Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into these plea bargain agreements, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, I did.
In each cause number, did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Counsel, in each cause number, did your, I'm sorry, I'm just seeing who's coming in. All right, in each cause number, has your client been able to provide you with any defenses?
Yes, he has, Judge.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
In each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe so, as to both cases.
Mr. Ross, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State is silent on your application. The cases were run concurrently. There's to be no contact with the complainant. And in the cause number ending in 33, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea? Defense, is that the plea?
Yes, that's my
State.
understanding.
Is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, are there any such motions?
No, Judge.
Then in cause number 2025 CR 003533, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR 004086, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, with regard to both cases, state offers in the evidence they consider the form of the evidence.
Any
No,
objections?
no objection, Judge.
In each cause number, did you review the waiver and consent to stipulation of testimony with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Sure.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates. I don't see the December 6th, December 11th.
What those dates are referring to, which I guess we could figure out how to put in the stipulations were, those were days that the defendant called the victim from jail. So those would be reported to jail.
All right, so,
And we've been provided with those, Judge.
I'm sorry.
We've been provided those.
Well, are you stipulating that, because he pled no contest? Is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024, and December 11, 2024? And December 15, 2024, December 20th, 2024, and January 25th, 2025?
We're
The last date was not, that was the part of the report attachments where he had allegedly had contacted her through social media after the alleged incident.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses. The
Well, no,
state
no, no,
can-
no. I'm
No,
trying
but
to see if
I'm
there's,
trying to get there. I'm trying to get there. As to our application for, we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then
well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order. But the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR 03533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
so I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI. And just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today.
All right, and counsel, where are you saying this?
Can you repeat
this-
the dates, Judge?
The dates that
That they're in question?
the dates that are in question for the court are. I have a December 3rd. I have a December 5th date. So December 5th and count 1, that's paragraph 1. So I'm looking for the December 6th date. I don't see the December 6th date in here. And then there's a December 11th date. I don't see the December 11th date in here. Okay, so where's the,
I think you downloaded it, and put it on the disk to have as part of the stipulation. If need be.
Well, December 2nd was the date of office. I was just trying to confirm that, Judge.
well, so here's the thing. If he's not going to stipulate that what's in the indictment, the dates, then we can't proceed. I can't proceed on those dates. And if there's no additional information that's given to the court, then the court is going to find him not guilty of this because,
And Hunter, if I may, Ashley Jones for record. All that's required for the statute is 2 offenses within a 12-year period. The first offense is going to be, December 5th, which is listed in the report, and then the second offense would be the January 25th date, which is in the report. So that would be 2 violations within a 12-month period, and we can scratch or amend the.
All right, so y'all want to admit, all right. So we're back on the record. Well, I don't even see the January 25th date in here.
It says January 23rd, yes.
Well, that's well, they have it listed as report time. I don't know if that's the report time when they made the police report or the report time for this offense. Wait, just one moment. Let me see. All right, you're correct. So that on or about date time is the time when they filed the report, but also the time when she's saying it happened. So the court will find there's sufficient evidence to find you guilty in 2025 CR 004086. The court will defer finding of guilt as you apply for deferred adjudication. And you're saying that you wish to waive PSI?
That's correct.
All
That's
right, what do you wish to say on behalf of your client?
Your Honor, my client, he's 27 years old. He is not a native to Texas. He's from Indianapolis, Indiana. I'm sorry. Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old, is that right? 16? 15. Since they were
All right, does he
15.
want to testify?
No, Judge, let me just finish. I'm so sorry.
All right, so you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay, I'll just
All right.
proceed. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement. And if he wants to hire a lawyer and, get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today, and I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry, I was confused about the city, that there was an actual jury trial and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much on with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim,
Due to what?
the witness leaving the state.
Okay.
So as we stand here today, we have, obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, you know, we know that that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is let me see, his name is Eggerson is his last name, Sergeant Eggerson, and I did call the number. Let me see, on Potranco Road. It's 11223 Potranco Road, and unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication
Okay,
legally?
well, I would ask the court to take that into consideration, that he has no legal convictions. Under any other ordinary circumstances, he has no prior offenses,
Okay, but,
convictions. And so,
But if you're
because he's a
saying he's-
first-time offender,
all right, but if you're saying he's legally entitled to deferred adjudication on this
I
case?
have no statute.
All right,
If the court, I have no statute, but I'm just saying as a matter of principle, as a matter of, you know, mercy on my client, you know, the court, I should hope, you know, at least, because again, you know, he's also been in contact with, being recruited, that he would be granted deferred adjudication. And, you know, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
all right, so what I can
And
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number ending in cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
They're gonna take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court
Can I
will hear that
please
motion.
speak on my behalf? Can I please speak on
I
my
don't know what
behalf?
you-
I just want to testify. I didn't.
Patrick Washington?